Hey, we know it is hot outside. A lot of Houstonians got a little taste of what it's like to live with no power last week, but some people suffered longer than others. People living at the Durham Heights apartment complex had to relocate because they had no power or running water for more than a week following severe weather on May 16th. This was after CenterPoint turned power back on to the rest of the community and their neighbors. The city of Houston declared the complex unlivable. And then on Saturday, CenterPoint did restore power, but many residents said everything's still not working. This morning, we're looking into the rights that renters have in a situation like this. Joining us this morning to tell us what those rights are and how you can stand on them is attorney with Lone Star Legal Aid, Donna Karni. Thank you so much for joining us this morning. How are you?
Hi, good morning, Amy. Thanks for having us.
Yeah, I mean, and Donna, I know we talk to you sort of throughout the year and on an ongoing basis when it's not an emergency, but I mean, it started as an emergency situation, and then as all of the other people in the community started getting power back, we hear, oh, well, it's this complex has to fix something with their electricity before CenterPoint can restore it, and then there's no water. What should renters in this type of situation do? It's an emergency, right?
It's absolutely an emergency, but this is not an emergency that the landlord will say the landlord caused. And yet it sounds like CenterPoint has done what it needed to do to restore the utilities. We urge tenants when there is a disaster to make their demands for repairs right away. Even if the landlord's going to come back and say, I didn't cause this problem, it starts a clock for tenants to be able to rely on the fact that they have demanded their repair.
Okay, so the first thing, put something in writing and say, and it sounds obvious because you'd be like, hey, everyone in my complex is complaining that we have no power. They've got to know this, but it's important that you put it in writing and send it to the office.
Absolutely. So we always encourage, I've always encouraged this, not just to tenants, but any consumer. If you're dealing with a merchant or a landlord in this case, in writing, certified mail return receipt, if you can hand deliver it and memorialize that, that is either recorded or videotape that you're hand delivering it. In Texas, you're not required to let the other person with whom you're communicating know that you're recording the conversation as long as you're a part of the conversation. So just go hand deliver a copy. If they'll sign that they've received it, that's great. If not, keep a copy for yourself, hand deliver a copy to the management, tape a copy on the outside of the door as well. Photocopy that, put it in their mailbox, send it certified mail return receipt. You want to make sure that this landlord cannot deny that they've received your repair request. Now, there's a presumption, there's nothing written into the law, but there's a presumption that within 7 days the repair should be made. And very importantly, Texas tenants need to know you are not entitled to demand repairs if you are behind on your rent. So make sure to pay your rent if you want to demand a repair.
Yeah, that is really good to point out because we know that basically if you just say, well, forget it, I have no power, I have no water, I'm not even going to pay for my rent. In this situation, we know many of those tenants were able to or went to a hotel to stay because they're like, we can't stay there. I mean, it's getting to be 100 degrees inside the apartment. Are they entitled to anything? Are they entitled to, request or somehow get compensated for the time that they could not live in their apartments?
So it'll be interesting to see kind of on a case-by-case basis, and I think it is important for the public to know. It's challenging for me to give legal advice kind of just based without having seen anybody's lease or individual circumstances, but I do understand that there's a document that's been posted by the city on this particular property. When an authority comes in and says that a property is not habitable, that becomes a real problem for the landlord. And the question's going to become, how long is it not habitable? And with these scorching temperatures, if there's a water pressure problem that prevents chillers from operating, if there's an electrical issue that prevents, obviously, air conditioning and other, refrigerators from operating or other medical equipment from operating, there's a question as to how long is this place going to be uninhabitable. If a property is totally uninhabitable and it is the product of a casualty loss, the property code is very clear that if the casualty loss is not the negligence of the tenant, then either party can terminate the lease. That has to be done in writing. And as soon as the tenant has moved out, if the tenant has provided that lease termination, the tenant can also demand a pro rata refund of their rent for that month.
Okay.
I encourage tenants, again, put that in writing. As for the security deposit, seeing that this was not the sort of casualty loss where the roof blew off or part of the walls were blown off, it may be that the landlord would challenge how much of the security deposit is entitled back to the tenant, but that is something the tenant would be entitled to, as well as a portion, if not all, of their security deposit.
All right, we are almost out of time, but in situations like these, because this is a very specific situation, yeah, like you said, putting things in writing, you can't just leave and say, I'm done, I'm moving my stuff out, and not expect that they're not going to come back on you and say, hey, you owe all this money for back rent. So what should those folks be doing now if they say, hey, we still don't have water that's usable at a pressure that we can use it? Sure, we've got power, but water now has been not fixed, for going on 2 weeks.
Right. So back to where we started, and this is kind of advice that I think that the public should know. If there's ever a disaster, and no matter what the damage looks like, I think a tenant will want to send out a repair demand as soon as possible, immediately, and get that repair demand out, even if it's something that, may be clear that it's on the utility company, or may be clear that this was force majeure, something that was totally outside of the landlord's hands. But once that third party, like the utility company, does restore power, now it's on the landlord. And if the presumptive 7 days have passed and the landlord hasn't done their share, I believe the tenant may be within their rights to terminate that lease.
All right, Donna Karni, we appreciate your time this morning. Thank you so much for coming on and explaining this. We're going to put this interview, and we'll link it to other stories that we've done with Donna and Lone Star Legal Aid on renters' rights with those specific steps in case you're watching this and wanting more information. Have a great day today.
Thanks, Amy. Thanks for having us.
Thank you.